Welcome to Real News. Late last week, a decision came down from the usually reliably liberal Ninth Circuit out of California that has broken major ground in the gun rights debate and, in fact, has advanced gun rights, at least in California, or could advance gun rights across the country, and at least for the time being may advance them in California. The case is Peruta versus the County of San Diego, and I'm not the only one who thinks that this is a major case to come down for the Second Amendment. Paul Clement, the former Solicitor General, said the decision is very significant because most of the Court of Appeals have upheld carry laws. Once the Supreme Court said in Heller and McDonald the Second Amendment protects the individual right to keep and bear arms, then you can no longer expect business as usual. Well, what's he referring to? We know from D.C. versus Heller that the Second Amendment is now, based upon existing Supreme Court decision, is an individual right, and it is one that also has to do with the right to defend yourself. It is about self-defense. Therefore, you cannot have an outright ban on the possession of a firearm in one's home. But to keep and bear arms is what the Second Amendment says. What about this bearing part of it? Well, if you look at a map of U.S. right to carry laws across the country, you'll see that in many states, yes, in fact, you have permissive may issue or shall issue laws, meaning that you will get a gun if you want to get a gun and can carry it in some capacity. Either open carry, which means that individuals can easily see it on your person, or concealed carry, which means that they cannot, with the naked eye, easily see it on your person. Now, that varies from place to place. What's fascinating about this case in California is that the problem for those who wanted to abridge gun rights and truncate the Second Amendment is that they had both banned open carry entirely, even though until 2010 actually that was legal in California. They banned it entirely, but they also made it really, really hard to conceal carry. Now, that's where this notion of bearing arms comes in, and this is from the decision itself. The Second Amendment secures the right not only to keep arms, but also to bear them. The verb whose original meaning is key in this case, saving us the trouble of pulling the 18th century dictionaries ourselves. The court already has supplied the words plain meaning at the time of the founding, as now to bear meant to carry. So based upon a literal reading of the Second Amendment, to bear arms means that in some way, in some capacity, you have to be able to actually carry those arms on your person as an individual right to defend yourself. In fact, the decision went on to say that speakers of the English language will all agree bearing a weapon inside the home does not exhaust this definition of carry. For one thing, the very risk occasioning such carriage, confrontation, is not limited to the home. The idea here being that, of course, if you're supposed to be able to defend yourself, it can't just be in the home. You should be able to defend yourself at all times, in all places, somehow, whether it's concealed or open. So this was a 2-1 decision. Only 3 members of the court heard this. This now could open up the door. It could expand upon existing law right now in this country, which says that, yes, you can't, as a state or as a municipality, ban the right to have a firearm, but can you eliminate entirely the right to carry one? Joining us now is Dave Kopel. He's a professor of advanced constitutional law at the University of Denver and a research director of the Independence Institute. Thank you very much for joining us, Dave.
Oh, thank you for having me.
So how big a deal would you say this is for the Second Amendment? It seems to be at least the opening for a whole new understanding from state to state, assuming that this would be replicated, assuming that the Ninth Circuit doesn't overturn this upon an en-banc review. But this could be a really big deal, couldn't it? People all of a sudden now would have to be afforded either open carry or concealed carry rights by their state and by their municipality.
And in almost all the country, they already are. There are only 8 states that currently deny the right to bear arms. California was one of them, and Hawaii, also in the Ninth Circuit, was one of them. So, as you say, assuming the Peruta decision doesn't get overturned at some future point, we now have 2 states, one of them which has 1/9 of the U.S. population, where the right to bear arms, which had been almost completely obliterated in that state, will now be restored to the citizens of those 2 states.
A recurring theme in the opinion was that there's a difference between regulating a right, and even in the Heller decision, it was clear that they don't think that you have an unlimited right to carry any firearm, anytime, anywhere. But the difference between regulating and destroying a right, and it seemed that, at least in the majority in this case, it was only a 2-1 decision, the majority seemed to say, listen, you can't just make it essentially impossible for somebody to get a gun, which is what they were doing in San Diego. You had to have good character and had to prove that somehow you were different from other people who also want a gun. You had to have some imminent threat to life. It was up to the sheriff to decide whether you actually had any Second Amendment rights at all outside of your home.
Exactly. The Peruta decision by the court does not in any way call into question California's statewide statute about giving people licenses for concealed carry of handguns. That license requires that an applicant have good moral character, and it also requires that the applicant have good cause. In many California counties, the good cause requirement has been interpreted properly, that the good cause is you are a law-abiding citizen who wants to exercise your Second Amendment right to bear arms for lawful protection. But in San Diego County, Los Angeles County, up in San Francisco, and some of the other populous counties, there was a requirement, instead of the perverted good cause, to say that you have to be under an imminent specific threat, that you had to have some kind of compelling need.
Yeah, I don't want to get too far afield from the legal analysis here, Buck, but the whole point of gun ownership is to have it when you don't anticipate needing it. The whole saying is it's better to need a gun or to have a gun and not need it than to need a gun and not have it. So I don't know how you would prove that to the San Diego Sheriff's Department, that I potentially will need this. Maybe you have a restraining order against somebody, I don't know. But that's beside the point. The legal analysis, I think, is interesting, and the potential for this to go to the Supreme Court. If I could, I'll go right back to Dave. Dave, what's the likelihood this is going to go to the Supreme Court? Whoever loses this at the Ninth Circuit appeal, if it goes to an en banc hearing, will this most likely go to the Supreme Court?
Well, I sure hope that it does, because I think the Ninth Circuit, like the Seventh Circuit, which struck down Illinois' complete ban on gun carrying back in 2012, correctly followed what the U.S. Supreme Court said in Heller and McDonald, which you have a right to keep arms and you have a right to bear arms. And neither right is unlimited. It's okay to have regulations on the carrying of arms, including banning gun carrying in sensitive places, such as schools and government buildings. But you cannot entirely obliterate and destroy the right so that 99% of law-abiding Americans can never exercise that right.
Terry, what we saw here is once
if the Supreme Court takes it.
Terry, we saw the progressive sort of anti-gun lobby really overreaching through this legislation. Yes. In this case. They were being too cute. They banned outright guns that could be open carry, and that was enacted relatively recently in California. And then on top of that, they said, we're going to make it essentially impossible. Imagine if you did this with voting. You have to take a 4-hour written exam before you vote. You have to wait 7 days before you vote.
Well, I mean, this is clear. As I was taking notes on this, the first thing I wrote was overstepped. I mean, when you have the Ninth Circuit coming in and saying, I don't know, I think, you guys went too far, then they freaking went too far. I mean, the Ninth Circuit is as liberal as it gets. But this is just another blow to the anti-Second Amendment group. I mean, these people have been out of control lately, and they've really gone after gun ownership. And, since Newtown last year, they, at the federal level, the Obama administration tried to do executive orders here. They couldn't get anything passed in Congress, and they keep going, and now these things are getting shot down in the courts. So it's clear that at least the Second Amendment is still alive and well in the Constitution.
That's what's interesting to me about this. The experts that are tied close to this case, they said that there will probably be a rehearing for it, and it will eventually go to the fuller Ninth Circuit, and they said it will probably go to the Supreme Court. But I do think, regardless of the fact that you had 2-to-1 at some level say that this is an overstep, I think it does show, to your point, that there are some limits to what gun control advocates can do, and they clearly overstepped here because they essentially negated half of the Second Amendment by putting out all of these different restrictions.
And I'll just note, moving forward, I mean, you saw what happened at the D.C. Circuit when they didn't like the decisions coming down. They got rid of the filibuster, nuclear option to the whole thing. Now we have a packed D.C. Circuit. It's very likely we could have a Supreme Court nomination this summer and an opening. And this becomes all the more important when we're looking at elections, when we're looking at Harry Reid and what all he's been doing. These are the cases that matter.
This is going to really kick up a lot of opposition, even though, as we've pointed out, it could be reheard by the Ninth Circuit. They could have a panel of 11 decide that this is actually, they're going to remand in a sense. They're going to turn over the decision that was made here. But already we know that the Brady Center to Prevent Gun Violence has come out and said neither history or precedent supports this aberrant split decision that concocts a dangerous right of people to carry hidden handguns in public places to people whom law enforcement has determined they have no good cause or qualifications to do so. Will, this is a misunderstanding, actually, of what was said in this case, because you can still ban concealed carry as a state. You can do that. That's okay, even under Heller. You just can't ban concealed carry and open carry.
So that's
a negation. That's a negation of the Second Amendment.
That's the point you made to Professor Kopel. You can't destroy a right. You can regulate a right, but you can't destroy a right. But I'm actually interested to see where this is headed. If you take all of this in its totality, what we have now is D.C. versus Heller saying you have an individual right to possess and own a gun. Now you have this case saying you have an individual right to carry a gun. Put up your map that shows the number of states that are going to shall issue permits. What I'm curious about is where this goes down the road. If you're not destroying, if you're just regulating it, and we go back to Professor Kopel, Do we see the day when the Supreme Court or courts start to say, you know what, you can't require it to be concealed? I know it's a balancing test and the state has to show an interest, but this thing is moving in the direction of gun rights, gun owners' rights, and I'm curious where it could go.
David, let me pose that to you. This is obviously a California decision. It affects the Ninth Circuit. So California and Hawaii are affected by this for now. But New York is the other state where we are right now, where they make it essentially impossible for you to conceal carry or carry in any capacity. Do you think that the states will try, that the few remaining states that have issues with this regard are going to try to tweak their laws so that they wouldn't necessarily run so obviously afoul of it? Or are they just going to wait and see if this gets kicked up to the Supreme Court and deal with it after the fact?
Well, the laws in Maryland, New York, and New Jersey, which restrict carry in a similar way, and actually not really the laws themselves as much as the bad application of them by the issuing authorities, especially in New York, have been challenged, and some of those cases, one of the New Jersey case called Drake is actually pending before the United States Supreme Court right now for the court to decide whether to grant certiorari and hear the case. And I don't see Governor Cuomo in New York having any inclination to move New York in a more constitutional direction.
And Terry, you know, there's two sides of this as well. Not only are they making it essentially impossible for the vast majority of people to get in New York City and in California, concealed carry permit, but also if you're connected, if you're politically,
Howard Stern got a gun.
You can
in
make
New
the
York
right
City.
phone call. All of a sudden, then the Second Amendment applies to you.
Yeah, well, you know, it's this is selective enforcement. It's, you know, people trying to apply something that doesn't make sense unless it applies to them, and then, you know, then they have a change of heart. But that's typical progressive stuff.
All right, we'll keep an eye on this one. David, thank you very much for your time tonight.
Thank you.